how to prove it, because bringing evidence into court is so complicated. Even attorneys screw it up. Let's go through how you can prove your point and bring in your evidence and what that all means. And first, I'm going to start with one of the biggest misconceptions and biggest mistakes that I see from attorneys and from individuals alike. If you filed a document, a declaration, an exhibit, a text message, anything prior to trial, that doesn't mean that the court can consider it during trial. You actually have to bring all of that same information into the trial to have the judge consider it for a decision. Trial, evidentiary hearing, all the same. And if you don't, that means the judge isn't looking at it. But most people assume the judge has because they filed it. Not the case. So to bring in that same evidence that you've already put before the court and had the court hopefully consider in a trial, you're going to have to bring in the person that wrote the text message, the person that recorded the video, the police officer that made the report, the therapist that wrote the letter. All of them, they have to come into trial. Even though maybe you filed them and the judge said that they did a cursory review. Why? Because it's in trial or evidentiary hearings that right to cross-examine, all of those pesky rules and constitutional rights come into play. So if you don't bring it back up in trial, it's not considered. And you have to ask the court not only to admit it, but also you have to do all of the laying of the foundation, which is why you bring those people in. And at the end, you ask the court to admit all of your evidence that you just brought in to trial.